Hi, it's me, Brodie McLeod, again on YouTube. So I just saw a couple of people from an ICB. ICB stands for Integrated Care Board in the foyer at Hayward Ward or at Signet Qstoke, and got chatting to them briefly, showed them the pinned tweet that I've got on my Twitter page of the video about mental health funding and the Supreme Court ruling of Swindon versus Worcester, which effectively said that this thing called the first funding principle no longer applies. So in a nutshell, let's say you were sectioned in 2020 in London and then you moved to Manchester and you were sectioned again in 2025. The first funding principle means that even if you've lived in Manchester for five years, the NHS Integrated Care Board and Trust in London, where you used to live 5 years ago and you don't live anymore, is still responsible for your treatment, and you might be taken to hospitals funded by them and beds funded by them in an out of area placement. The Supreme Court, when it passes a ruling, it becomes the law, something called the precedent of doctrine. So I've just done some AI research about that. I asked, does the NHS guidance entitled Who Pays from 2024, which states in paragraph 18 that mental health treatment will still be applied on the first funder principle, contradicting the Supreme Court ruling set by the Swindon versus Worcester case passed in 2023, and so therefore also the precedent of doctrine, contradict or contravene the laws surrounding Supreme Court rulings? If so, which laws are NHS England breaking by continuing to disregard patients' place of ordinary residence stipulated by the Supreme Court ruling as to be defined by where they live, and so to be used to determine the relevant Integrated Care Board for detained patients? It says NHS guidance and Supreme Court ruling on patient funding, a potential conflict. NHS England's 2024 Who Pays guidance, specifically paragraph 18, maintains a first funder or originating ICB principle for determining responsibility for mental health treatment, including for detained patients and their aftercare under section 117 of the Mental Health Act 1983, MHA 983. This approach has raised questions regarding its consistency with the 2023 Supreme Court ruling in R on the application of Worcester County Council versus Secretary of State for Health and Social Care and Swindon Borough Council 2023 UKSC 31. The Supreme Court in this case clarified that for the purposes of local authority responsibility for section 117 aftercare, which is different from the care that's the care you receive when you leave hospital, not the care you receive when you're getting treatment in hospital. A patient's ordinary residence is to be determined by their actual place of residence immediately before detention. At the heart of the issue is how Integrated Care Boards, ICBs, determine which of them is responsible for funding the care of a detained patient, particularly when the patient may have been moved from one area to another prior to or during their detention. NHS England's stance. NHS England asserts that the Worcester Supreme Court judgment does not affect the operation of the rules relating to establishing the responsible NHS Commissioner for detention and aftercare under the Mental Health Act 1983. It directs Integrated Care Boards to continue applying the rules set out in paragraph 18 of the Who Pays guidance. This position is reportedly based on the National Health Service Integrated Care Board Responsibilities Regulations 2022. This is what they cite. NHS England interprets these regulations, particularly regulations 5, 6 and 7, as establishing a distinct regime for Integrated Care Board responsibility. This regime, they argue, allows for the originating Integrated Care Board, often the ICB where the patient was first detained, or for whom the ICB first assumed responsibility. So i.e. that could be somewhere you lived 20 years ago. For me, Devon Partnership have been involved in my care and I haven't lived in Devon since 2019. It's 2025 now, that's 6 years that I haven't lived in Devon. So that first assumed responsibility to retain funding responsibility, even if the patient subsequently becomes ordinarily resident in another Integrated Care Board's area prior to a later detention or for the purpose of section 117 aftercare. This is akin to a first funder principle. The Supreme Court ruling in Worcester. The Worcester judgment focused on determining which local authority was responsible for providing section 117 aftercare services. Section 117 Mental Health Act 1983 places a joint duty on local services authorities and the NHS, now Integrated Care Boards, to provide aftercare services to certain categories of patients detained under the Mental Health Act 1983 upon their discharge. This Act stipulates that the duty falls to the local social services authority in the area in which the person concerned was ordinarily resident immediately before being detained, and the relevant NHS body. The Supreme Court decisively ruled that ordinary residence should be given its usual established meaning, referring to a place where a person lives voluntarily and for settled purposes. Critically, for subsequent detention, ordinary residence is determined by where the patient was living immediately before that specific detention. The ruling rejected arguments for deeming provision or that the initial placing authority would always retain responsibility if a patient was moved to another area. Potential contraindication and legal implications. A potential contradiction arises because Section 117 of the Mental Health Act 1983 imposes a joint duty on both the local authority and the NHS Integrated Care Board. If the local authority responsible for Section 117 aftercare is determined based on the patient's ordinary residence immediately prior to detention, as it was in the Worcester case, as per Worcester, but the responsible Integrated Care Board for the same Section 117 aftercare and other mental health treatment is determined by a different first funder or originating ICB principle as per NHS England's guidance, this creates a divergence in how responsibility for the same patient and the same episode of care is established between the two key statutory partners. The doctrine of precedent, stare decisis, is a cornerstone of the UK legal system. Rulings from the Supreme Court on points of law are binding on all lower courts and public bodies, including NHS England. While the Worcester case directly ruled on local authority responsibility under Section 117, its interpretation of ordinary residence within that statutory provision is highly persuasive, if not binding, for the NHS component of that same joint duty, unless there is a clear and distinct statutory language or regulation that lawfully mandates a different approach for integrated care boards. So it's kind of saying, well, it says what it says. NHS England points to the Integrated Care Board Responsibilities Regulations 2022 as providing this distinct statutory basis. A detailed legal analysis of these regulations would be required to ascertain if they unequivocally and lawfully create a parallel system for determining ICB responsibility for detained patients, including for Section 117 aftercare, that overrides the common understanding of ordinary residence as applied in Worcester. Which laws could be contravened? If NHS England's guidance, by continuing to apply a first funder sorry about this. If NHS England's guidance, by continuing to apply a first funder or originating ICB principle that disregards the patient's actual ordinary residence immediately prior to detention as defined in Worcester, is found to be inconsistent with the Mental Health Act 1983 as interpreted by the Supreme Court, or the superior legal status of the Supreme Court's interpretation, several legal principles could be engaged. First one is just the rule of law. Public bodies must act in accordance with the rule of law. If the guidance misinterprets or misapplies the law as clarified by the highest court, it could be acting unlawfully. Ultra vires. Public body guidance cannot lawfully contradict or be incompatible with primary legislation like the Mental Health Act 1983 or the Health and Care Act 2022, which establishes integrated care boards, or binding judicial precedent interpreting that legislation. Guidance that does so may be deemed ultra vires, which means beyond the powers of the body issuing it. Irrationality, unreasonableness. Wednesbury unreasonableness. If the guidance leads to a position that's so unreasonable that no reasonable public body would have adopted it, it could be challenged on these grounds, although it is a high threshold. Breach of statutory duty. If the guidance leads ICBs to fail to meet their statutory duties under the Mental Health Act, for example, to provide Section 117 aftercare in conjunction with the correct local authority as determined by ordinary residents, this could be a breach of those duties. Legitimate expectation. While less likely to be the primary argument here, if previous practice or statements had created a legitimate expectation that ordinary residents would be the determinant factor for integrated care board responsibility in line with the local authority determination, sudden deviations without clear legal basis could be challenged. The crucial point would be whether the Integrated Care Board Responsibility Regulations 2022 genuinely provide a distinct and lawful basis for determining ICB responsibility in the manner that NHS England suggests, even when this diverges from the Supreme Court's interpretation of ordinary residence for local authorities under the same Section 117 Mental Health Act 1983. If the regulations are found to be ambiguous, or if their interpretation by NHS England is seen as stretching their meaning to circumvent the Worcester principles for determining the responsible health commissioner for detained patients, legal challenges could argue that NHS England is acting contrary to the law. It's important to note that NHS England maintains its guidance is lawful based on its interpretation of the specific regulations governing ICB responsibilities. The situation highlights a complex interplay between primary legislation, statutory instruments, regulations, statutory guidance, and judicial precedent, particularly in areas of joint responsibility between different public bodies. Resolution of any perceived conflict may require further legal qualification and challenge. Well, I hope you enjoyed that and found that very interesting. I've got my ward round in a minute, and I've just been out for a cigarette in the rain. I'm going to moisturise and get ready for my ward round, and hopefully find out a bit more about the new hospital I'll be travelling to quite soon, and look forward to finding out who's funding it, whether that will be Devon Partnership Trust, the trust which governed patients who lived in Devon, where I haven't lived for 6 years, or Bristol, where I have lived for the last 4 years. And hopefully the lady in the foyer, I've still got some mint tea, hopefully the lady, and I've got a mark where I'm wearing my ridiculous flat peak hat because I'm bald and old and wrinkly. Hopefully they'll the ICB ladies will look at my pinned tweet and they'll be like, oh, look at this. This is a really relevant point. People could be carted off to out of area placements all over the country, and the NHS is basically ignoring the Supreme Court, so that Devon Partnership Trust can keep treating patients like me, and maybe even carting them off to Devon, or funding, the people who are taking care of us as mental health patients, and causing loads of people loads of distress and anguish and anxiety and suffering, and meaning the families have to drive hundreds of miles to go and see them and all that kind of shit stuff that no one really likes. But yeah, thanks for watching this far if you have done, and I'd recommend peppermint tea, works wonders.